Well, thank you very much for the opportunity to speak to you today, and particularly on the launch of this great program. It's wonderful to be part of such a great smorgasbord of different perspectives on this topic. And as someone who has approached issues of security, terrorism and the like over many years, it's crystal clear to me that the sort of collaborations that we're talking about are vital to better understanding these problems, but even more importantly, coming up with solutions that actually traverse the different disciplines and give us an opportunity to meet effectively some of these challenges. What I'm going to do today is I'm going to talk about the law, but in part this is really a call to reach out to other disciplines, to look at other perspectives. I'm also going to focus on Australia because it's an exceptionally interesting example for some of the legal problems that we're facing in this area. But again, many of the issues that I'm talking about travel equally well across the United Kingdom, the United States and other countries. Because when we talk about how legal systems respond to terrorism, here of course we are talking about a truly global threat and one that raises very common issues across Western nations. The key question that I want to ask in this talk is to analyse how we should protect the community from terrorism while at the same time seeking to preserve the basic democratic values that we are seeking to safeguard from terrorist action. How do we stop terrorism while protecting freedom of speech? How do we stop terrorism while respecting the privacy of people within our community? And these are questions that are perennial questions but have become especially acute around the world over the last 16 years. And of course these are questions that emerged most strongly after the September 11 attacks with the Patriot Act in the United States, legislation in the United Kingdom and Australia. And what we have seen since that time are successive waves of legal responses, whether it be due to the London bombings of 2005 or indeed the succession of attacks that we have seen around the world. If you look at how politicians and governance systems have responded to terrorism, one thing that's very quick to be noticed is that the law tends to be put as a first-order response. That a terrorist attack provokes a desire for more laws, more regulation, typically more coercion. And this reveals the fact that if you are a politician who feels an intense need to respond, to do something, to match and respond to community grief, one of the very few levers that has immediacy and public traction is law, is the notion that we're going to be tougher on crime, tougher on terrorism. So what we've seen over this 16-year period is a ratcheting up with cycle after cycle as politicians reach for more and more examples of things that they can do in response. What we haven't tended to see is questioning in the public domain about whether that's been effective. Is this ratcheting up actually making communities safer? Is it actually doing more to prevent terrorism in the first place? And even though I am someone who strongly believes we need appropriate and well-calibrated anti-terrorism laws, I think it's becoming increasingly obvious that we do need to ask those harder questions. Is this working? Is our strategy with such a legal focus actually the right one for dealing with some of these problems? Many of these laws, when they were initially passed, came onto the statute books on the basis that they were short-term, they were exceptional. And indeed, much of the language in this area from our politicians is that in response to this attack, we need to defeat terrorism. The war on terror is something that will go for a period of time. So we need these exceptional measures that were unthinkable prior to those attacks, and we can be assured that they will be removed from the statute book soon afterwards. So what we're dealing with here is a body of law that by its very nature is seen as short-term, transient, and something that should not be with us for a longer period of time. Now, of course, it hasn't worked out that way. What we've got in this case is a conflict that has lasted for a longer period than World Wars I and II combined. And as a result, we have a body of law that was seen as exceptional, as breaking the normal norms of how a system of government should work, and in doing so has actually introduced a series of measures that, far from being transient, actually are taking on a character of permanence. And that's because this conflict, of course, has no obvious end in sight. People are now talking about a generational struggle. And we're also talking about measures that over the course of time are simply becoming part of the furniture. In fact, they're being copied in many areas of law that have nothing to do with terrorism. So what was exceptional is increasingly becoming normal, simply through the effluxion of time and as people get used to that system. So again, what we have here is counter-terrorism measures driving broader change within legal systems and government, and what we have is a long-term change that we are undergoing in how we are governed, how we accept our relationship with the state, what it means to be a citizen in a Western democracy, and these things are being very significantly reshaped by the introduction of laws that were meant to be short-term for a few years, but are anything but. And here we're seeing the so-called war on terror driving a broad range of policy and legal outcomes. And again, I'm not saying we don't need the anti-terror laws, but we do need to question the impact and the broader scope that they are having. Now, what we therefore have in this body of law is a system that responds to a security threat that very clearly is here to stay for the longer term. And one notorious fact in this area is that it's very rare to ever get any of these measures repealed. Once they're on the books, it's almost impossible to find a politician who's prepared to bear the risk of winding these laws back, if only because maybe there will be an attack and that person will be blamed for deaths or other harm by virtue of them removing this measure. So we're talking about a ratcheting up without much possibility of actually removal, even where numerous reports around the world are saying that laws actually are ill-calibrated or ineffective or actually counterproductive. And it's here I want to give you a snapshot of where we are in Australia on this. In Australia, we had not one national anti-terror law prior to the September 11 attacks. It was an unknown field of law in this country at the national level. We quickly made up time though, and we did so even though of course we have a lower threat in this country compared to other nations. I would say though that it's quite hard of course for myself to know exactly what the threat is, and I must acknowledge that I deal with imperfect information in this area. I also deal with the fact that it's very hard sometimes from the government material to actually understand what the threat is. Until some years ago, we had a system in Australia which defined the threat as being low, medium and high. And if you went to the Terror Alert website and looked up what medium was, it said there is a medium risk of a terrorist attack. And I found that not overly helpful in actually understanding what this meant. They've now changed it, so we're talking about a likely or very likely threat. But still, the information is imperfect, certainly in this area. But no doubt there is very clearly a threat. Australia's response to September 11 was to make up time in an extraordinary way. And what we have done since that time is, to my knowledge, passed more anti-terror measures through our federal parliament than any comparable country. In fact, since September 11, Australia has enacted 66 separate anti-terrorism statutes through our federal parliament alone, which far outstrips, for example, the United States and the United Kingdom. At the high point from 2001 to 2007, 48 of these anti-terror laws were passed, and we had a new anti-terror measure in Australia every 6.5 weeks being passed through the federal parliament. And these often run to hundreds and hundreds of pages. These are enormous measures. In fact, Australia has never in its history gone through such a sustained period of lawmaking on any topic as it has on making anti-terror laws over the last 16 years. One international scholar, Kent Roach from Canada, who's compared a range of democratic countries, describes Australia under the topic of hyper-legislation, that we are unlike any other in terms of the sheer volume of anti-terror laws that we've enacted. And here it's been the familiar cycle: an attack anywhere in the world that tends to gather significant media interest, provokes a response from our politicians in the form of new legislation, a request to the agencies to come up with a new thing that needs to be dealt with, and as a result we get a new measure, whether sometimes it's sensible or not. It tends to be very quickly run through the parliament, often in the space of just a couple of weeks. In the case of state legislation, sometimes it's introduced and passed in the same day. And so within a very short period of time, we have a new measure, often with inadequate scrutiny, that suddenly becomes part of the apparatus. What's also striking about these 66 measures is that I cannot think of a single measure that was opposed by the opposition. So every one has gone through Parliament with bipartisan support. Not only that, the opposition now has taken to writing to the Prime Minister when the Prime Minister has announced a new measure, saying that we will pass that measure even before they've seen the bill, the detail. They even tend to expedite the measure and say we'll guarantee its passage within a space of 4 to 6 weeks. So we have a system where the major parties are in lockstep, they control the Parliament, and there's a furious willingness on the part of the opposition to support any measure that the government wishes to pass. And it means for civil society or people like myself who want to participate in a process of scrutinising, suggesting improvements, there are very few opportunities to actually, as part of that process, actually change course. It's too late. There's agreement, it's going through, and it leaves hardly any scope for political or legal engagement. if you look at the sorts of things that these laws do, they're not just extraordinary in number but in scope, and many of these of course have parallels in the United States and the United Kingdom, but in Australia there are a number of measures that have no parallel in those other countries or indeed in any democracy. And that's partly because we've run out of the sensible things to do, in part, and the need to respond has thrown up a range of measures that you simply would not contemplate in some other countries. So to give you a snapshot of some of the sensible but also the full list, we of course start with, as is needed, a clear criminal definition of terrorism. It's a definition that covers people who engage in creating harm, murder, assault and the like for a political, religious or ideological cause where they're trying to coerce the government or the community into an outcome. But that's a definition that has no exceptions for freedom fighters, for struggles of liberation. So certainly Nelson Mandela is a terrorist under Australia's system. Indeed, a range of movements in East Timor or elsewhere are covered by that. Anyone who commits one of these acts is subject to life imprisonment, but there's a range of offences that go beyond that. So for example, if you possess anything connected with terrorism, that can land you in jail for several years. Now, thing is not defined, and I imagine there are many academics who possess a thing that is in some way connected with terrorism. And it's an example of an offence where you just rely on the authorities not to prosecute. That surely it's appropriate that I possess certain things connected with terrorism because it's necessary for my academic work, but it gives great power to the authorities to pick and choose how they actually enforce these offences. We've got the police now can conduct warrantless searches of private homes, so your own home without needing any permission where there might be terrorism involved. Organisations are banned by government decree, and any person who is a member or an informal member of that organisation can be jailed up to 15 years. And it may be, for example, you've joined the organisation with no knowledge of its terrorist activities, but you're caught automatically by being a member. Preventative detention orders by which people can be taken into custody without charge or trial. They cannot be questioned, they can be held for up to 14 days, and they can be disappeared. In fact, the legislation says that they're allowed one phone call to their family, and there's a script that they must read out, and they cannot deviate from the script. A person in detention can tell their family that they're safe but cannot be contacted for the time being, and then they must hang up. And they're held for 14 days, and that's the only contact they're allowed. Heaven knows what someone would think upon receiving such a call, but perhaps if they Googled the words, they'd find out that they actually relate back to this legislation. A control order regime based on the United Kingdom, which lets people be held for house arrest or a range of limits upon their liberty, restricting their internet use, on rolling one-year warrants. People who are released from jail or due to be released from jail can be held indefinitely post the term of their sentence if it's thought they pose a continuing danger. One power that is not found in any comparable country gives our security intelligence organisation, ASIO, the ability to question and detain any person, suspect or not, and to hold them incommunicado for up to a week. And if, for example, you're a journalist who's being held for a week to get information about a source, if you don't answer the questions of ASIO, you can be jailed for 5 years. And that's a regime. There's no comparable regime where an intelligence service can compulsorily detain a non-suspect in that way. If a journalist wants to write a story about the detention, saying they were mistreated, that the government was abusing its power, the law also says the journalist for writing that story can be jailed for 5 years. That there's no capacity to write up information about misuse of power in this area. We have new forms of electronic surveillance that cover not just suspects but anyone who may communicate with a suspect. The Attorney General can close down courts from public view and prevent any media reporting, and can exclude the accused from their own trial in circumstances that mean they may be actually convicted of an offence without seeing the evidence that has been brought before them. A new censorship regime that means that anything that might be seen to advocate terrorism can be banned, including material that academics may wish to use for their study. But the definition of what actually leads to terrorism here is very slippery, and it means that material can be banned even where, according to the Act, it would lead someone with a mental impairment to consider terrorism. And heaven knows how the classification authorities will decide whether to ban something based upon someone with a mental impairment and how they would respond to that material. It defines mental impairment of someone with a severe psychosis or other condition, and if someone reading something might engage in terrorism with the benefit or disbenefit of that mental impairment, that's enough to ban that material. We've got a new metadata law which enables all of our metadata to be collected and stored mandatorily without the need of a warrant to access our material. We've also got a separate power that gives ASIO, the intelligence organisation, the ability to ignore domestic law when carrying out a special intelligence organisation, so they can operate extra-legally according to their actions. And here, if a journalist writes about their extra-legal conduct, such as they've killed an innocent bystander, the journalist can be jailed for up to 10 years. Another law that says that if a person enters certain parts of the world declared by the government to be a no-go zone, that person can be jailed for up to 10 years, even if they're there for an innocent purpose. We've got another provision that says that the government can revoke a person's citizenship if they're a dual citizen, where they may have engaged in terrorism but they have not been convicted. And it enables a person to deport people, to strip their citizenship, even where they've been acquitted by a court on the basis that the government views nonetheless that they think that they are engaged in those activities. And quite separately, we've got new measures coming onto the books. You may have seen, if you saw the news a couple of days ago, the Prime Minister with balaclava-clad SAS officers announcing a measure that the military will be able to assist the police in anti-terror measures. And separately, at the same time, that we will have laws that require the decryption by Facebook and other agencies of their social media content. That led to a statement by those that in fact this was impossible under the laws of mathematics, but I'm sorry, in fact these are debatable. The Prime Minister said that will not matter. The law of Australia will trump the laws of mathematics, and as a result they will have to decrypt this information even if it's mathematically impossible. Now there's a mix here of sensible and nonsensible ideas, and I put them all together, but it gives you a sense in the space of 16 years the journey that Australia has been on from no law in this area to an extraordinary range of measures that cover something as fundamental as who is a member of our community, through to stripping of their citizenship, through to mandatory forms of surveillance, through metadata collection, through to saying that an Australian can be jailed for 10 years for mistakenly entering a part of the world that they did not realise was on the no-go list. It shows that we've got a list of laws that are, truly extraordinary in their scope and application. And it is leading to questions as to whether they're all needed, whether they're effective, and whether our first order response based upon law is always the most appropriate way to go. Now, to conclude with a few observations about this and in general, it's not surprising to me, and I suspect it's not surprising to you, that when countries are faced with what particularly the media portrays as an existential threat, when people are worried about the safety of their families, when people are seeing graphic images of murder and mayhem in their own country or overseas, that at that point people demand action, and they demand responses from their politicians that keep them safe, and that in this system it's not surprising that politicians respond with measures that say, we will keep you safe, and of course vote for me as part of this, because I'm the one who's best placed to actually do that over the longer term. This dynamic is one that goes, of course, throughout human history. It's something that Alexander Hamilton wrote about in The Federalist in the late 18th century. In a different context, he said, safety from external danger is the most powerful director of national conduct. Even the ardent love of liberty will after a time give way to its dictates. The violent destruction of life and property incident to war, the continual efforts and alarm attendant on a state of continual danger, will compel nations the most attached to liberty to resort for repose and security to institutions which have the tendency to destroy their civil and political rights. To be more safe, they at length become willing to run the risk of being less free. And that's a really good encapsulation of what we have seen in Australia and in other nations. But why has Australia gone further? Why have we, with a lower threat level, done more in this space in the United States, the United Kingdom, even Israel, which has never adopted anything like the power of our secret intelligence organisation to detain non-suspects? There are many reasons, some political, some others, but one key legal reason is that Australia is now the only democracy in the world without a national Bill of Rights. When it comes to the question, what are the limits? What are the legal checks that can be put in place at this time of fear and grief? What constrains our politicians from going in certain directions? Well, Well, in Australia, the answer is certainly not. There's a statement of basic liberties and human rights that operates as a reminder of certain democratic values that must be kept in mind. When I've gone to the United States, as I did last year for an intelligence event involving agencies and others, I was asked by a number of people in the CIA and other agencies, how could Australia go down this path? And I gave them some of the examples, and they said, well, we couldn't even contemplate that given our Bill of Rights. We could not contemplate jailing journalists for writing material that is clearly in the public interest. We couldn't possibly strip away due process rights. So for them, they have a system, even with the pressures of politics, where certain things are outside of the frame of rational consideration. In Australia, we don't have that. There are no obvious legal limits to how far these laws can go. And as a result, we get some truly extraordinary responses. One of the difficulties in Australia with this debate is that we don't have a Bill of Rights, but people think we do. So the community actually thinks we are making laws in accordance with a set of checks and balances. And we had a survey a couple of years ago which asked Australians, a very large survey, does Australia have a national Bill of Rights? And 61% said yes, we do. They're obviously watching far too much US law and order and cop shows and getting civics education from sources that have no resonance with our own in this area. I saw this myself when I helped establish Victoria's Bill of Rights, and I went around the state asking again and again, do you want a charter or a Bill of Rights for Victoria? And very often people said, no, we've got the National Bill of Rights, we don't need this state instrument. And I said to them, well, what's in this National Bill of Rights that's protecting you? And the thing they pointed out most often is they said, I know I've got freedom of speech in this instrument. But the thing that came up second most often is they said, I know if I'm in court I can take the fifth. And that invocation of the Fifth Amendment to the United States Constitution, and I can't tell you how many times it came up, law and order was very popular at that particular time, gives a very clear indication of some of the public policy problems we face in Australia. How do you argue for a better system when people assume you've got a different system of what you've actually got? And here, as Jacinta was talking about, one of the key challenges is communication to the public, so that we can have a debate from a factual, well-informed basis, as opposed to a basis that has a set of assumptions that actually at odds with where we are. Another part of this I want to finish on as well is just asking the question about some of the counterproductive impacts of these laws. They no doubt, and they do, create a really strong coercive framework for dealing with terrorism and potential terrorism. I also don't doubt they have been effective in preventing terrorist attacks, and that's one of the important functions of these laws. But we need to ask whether an overzealous legal approach actually is in some ways fueling action towards terrorism as well. What we've seen in Australia is statement after statement, particularly by Muslim leaders, who are saying that much of the language and some of the laws are actually creating rifts and division in the community. And rather than leaders who emphasise social cohesion, cooperation with authorities and agencies, that we have laws that tend to divide and actually separate in ways that make terrorist recruitment easier and that actually create a sense of alienation, particularly young men, and all of our people charged with terrorism offences have been men, that perhaps this is not a country in which they're welcome, that even if they're born here, that this is not a place that they can thrive and be treated as an equal person. So, for example, Sheikh Wissam Shakari, a high school chaplain working in Western Sydney, said, I work on a daily basis with the youth, and what I see at the moment is severe distress regarding the new counter-terrorism laws. The Muslim community feels targeted and besieged. And this was just after former Prime Minister Tony Abbott said that everyone has got to be on Team Australia. You're either with us or you're against us. And he singled out Muslims and Muslim leaders in particular in suggesting that they perhaps were not on Team Australia. And as a result, we needed laws to deal particularly with that community. It's perhaps no surprise in this particular frame that the work of authorities when we seek to counter violent extremism is made much harder. That people are not as receptive as they might be to agencies who want to reach out, to actually take advantage of building trust and good links. It's also made harder because in Australia, community-based strategies tend to be more of an afterthought in this area. The law is the front line. Building social cohesion through community building policies tend to come afterwards. In fact, they were first introduced in 2005, but then the Abbott government tried to completely abolish them in 2014, suggesting that a legal approach was all that was needed. It eventually backtracked on this and gave $13.4 million as the initial money in this area. But $13.4 million compared to billions that are given for more coercive strategies, I think suggests something that's very badly out of alignment. The government now has given significantly more income in this area, but again, there's a lack of cohesion, a lack of clear strategy in this area, a lack of awareness of how community building strategies need to work with what often are necessarily coercive legal strategies, but perhaps too coercive in some cases given the counterproductive effects that follow. We need to ask whether we can actually devise a different strategy in this area that better understands radicalisation and the fact that our own strategy can tend to fuel that in counterproductive ways. So to put all this together, my own view is that the law clearly does need to be part of the solution. I'm glad it's part of Global Security Plus. It needs to be part of the conversation. But as a lawyer, I'm someone who will often say we focus too much on the law as being able to solve these problems. That perhaps people assume it can be a deterrent to terrorist action, which is how the law is meant to work. But in fact, in this area, the law is very ineffective as a deterrent. People often are uninterested in the consequences where they have been sufficiently radicalised. So what we need is a more holistic perspective, one that recognises law has a role, but a role that is better informed by other disciplines, other perspectives. And perhaps if we did that, we might actually come up with a strategy across our nations that is more nuanced and reflective both of some of the mistakes that we have made and some of the opportunities that I hope we have in the future for better dealing with these problems. Thank you.